One of the other very important questions we'd like to address in this video is about your intellectual property, or protecting your business and your intellectual property. The intellectual property is something other than physical property. So, for example, your business name or your logo, a tagline, a product name, these are things that you've worked hard to build, and now they are out there in a public way. If you don't want to have them used or taken by someone else, the only solution is a trademark. In fact, when you register your business name or corporation name, those are not protected. It's quite clear in the Act that it does not take precedence over someone else having a trademark. So you could register a business name or use a product name. Someone else could go ahead and trademark that name, and unfortunately they would be able to tell you to cease and desist or stop using it. This isn't something that you want to happen if any of these things are important to your business. So I'll repeat, a trademark is something that protects a mark, a logo, a tagline, a company name, a product name, something succinct like that. When you are building a body of content or other types of material that you want to protect, the answer is a copyright. So whereas a trademark is on an identifiable visual thing, a copyright covers a body of work, a book, a piece of art, a manual. It might cover even website. Many companies copyright what is on their website because, again, people can take that content and use it, and unless you have a copyright on that material, you're defenseless. So any of those key parts of the business that have a body of work, there you need to think about a copyright. What we do is we work with folks, with our experts in intellectual property, to understand these things, to make sure that a search is done to ensure that those trademarking items or those copywritten content items are not already in existence. So of course, if the logo comes up on a search that looks like yours, or a business name that looks like yours, or a product name that looks like yours, will tell you basically you can't trademark it. There are some fine lines, but the bottom line is, before you go ahead and do try to protect something, we'll do a search and let you know whether or not that's possible. That can be important. You might actually change a product name or a logo or a business name because you find it in a search. What the application process does is set the stage for your future registration. So a TM, which you get immediately upon making your application, it takes about 15 to 18 months before the government registers that trademark. It needs that time to investigate that no one else has anything the same or very similar. And if that were to happen, we would inform you that the government has an issue with it, and we would help you from that point. So we help you with the application process, and once the final registration happens, we ship that off to you. A trademark is good for 15 years, but then it is no longer valid, so you would have to reapply for a trademark. In the case of a copyright, you have 50 years. A patent is a different form of protection again. It is an invention. It is a physical creation. And patents work very differently. The interesting thing to know is that the way a patent works is that when you apply for a patent, it takes much longer to receive that patent. But one of the purposes is to actually put your invention out into the public. Of course, only once you've filed for a patent does the government do that. And it waits for a period of time to see if, in fact, that patent should be issued to you. If it's not an invention, if it's a copy of something else, that can take a long time to figure out. So it's a longer process. But if you're in the business of inventing, or you have invented something physical that requires protection, and is core to your intellectual property, please investigate the issue of patent. Those are the different forms of protection we wanted to share with you.